So they make some pretty good points in this video, but let's be clear. This is Joe Biden's criminalization of the justice system to win a presidential election.
That has actually practiced criminal defense and public defense, and as somebody who's done that for a very long time, I appreciate that very much. I never did practice in New York. I also have practiced in federal court, and I've practiced in state court and passed several bar exams as well. Judge Wilson, what's the statute of limitations on a misdemeanor in New York?
1 year.
When was this, what is the business records case is a misdemeanor, correct?
The underlying crime, the falsifying business records, yes, that's a misdemeanor charge.
So the only way to get to a felony is by committing is by in concealment of another crime.
Correct.
And each one of those crimes has specific elements.
That's right.
And you have to prove, in order to get a conviction at trial, you have to prove every element of the crime beyond a reasonable doubt, right? That's just traditionally how this works.
That is the right way to do it.
So in the indictment, did they put the underlying crime?
No, they did not. They only described it as other crimes.
Okay, and in the jury instructions, did they put the specific underlying crime?
No, the falsifying business records was described in the jury instructions. There was some brief description of the New York State election law violation, but there was no description given of the choice of three crimes. There was a description given of falsifying business records, which was pretty ironic because it was falsifying business records to falsify business records.
So, and that's also a misdemeanor, right?
That should be, yeah.
So you have 2 + 2 = 6. Like if you commit 2 misdemeanors, you get to the felony statute of limitations, which they had to get or they could have never brought the case.
That's correct, but there's some more question marks regarding the statute of limitations. It's not cut and dry because the time that Donald Trump spent out of New York could be used to toll the statute of limitations. That was the ruling in the Court of Appeals Harvey Weinstein case. He argued that the time that he spent out of California should not have told it, out of New York that is, in California, should not have told the time limitations, but the Court of Appeals ruled against him on that issue. So that's, I think, how they get around the statute of limitations problem in this case.
So was the election law case a federal election law or state election law underlying crime?
It seemed like it was charged as both. When we got to the jury instructions, there's a violation of New York election law charged, but then there's one among the 3 charges underlying is an unspecified violation of federal election law.
And then the third one was tax violation, right?
Also unspecified.
So all 3 of those underlying crimes have significantly different elements of the crime.
That is correct.
Were any of the elements of those crimes listed?
No, not at all.
So, this is important, and it might not be as robust or anything, but when you defend a client in court, if you don't know what the elements of the crime you're defending, how do you mount a defense?
You can't. That's the very issue of fundamental fairness that I referenced. You, as a defendant, are entitled to know what the charges are against you so that you can defend against those charges. Donald Trump was never made aware of what the extent of the charges were against him until the end of the trial.
And the elements of the crime go in the jury instructions. I mean, traditionally, that's how it works. Federal court, state court in North Dakota, state court in Minnesota. I've been in all of these different jurisdictions. You actually get the elements of the underlying crime, correct?
Any time that I instructed a jury, I instructed them what the elements of the crime were.
And instead, in this case, they got a grab bag.
They got a choice of 3 when it came to the underlying crimes, and we don't even know which ones they chose. So we don't know whether or not they could have been unanimous on those 3 or not. That's another failing of the jury instruction.
So not only did we have not the elements of the crime, but we had 3 different crimes with 3 vastly different elements of the crimes.
All unspecified.
None of them in the indictment. The elements of the crimes weren't in the bill of particulars. Last hearing, I had the bill of particulars waved at me like it was some kind of magic document that flew in here with its own cape.
So the statement of facts only describes a series of allegations, a series of actions that it's believed that Donald Trump took. None of them describe any criminal activity. None of them describe any, they don't describe any elements of any crime.
And that's why you believe as do I, that when this goes on appeal, there's going to be significant legal issues to argue that the jury never actually got them put in front of them.
I have very little doubt that this matter will be reversed on appeal and based upon these issues.
Because I've actually been I believe jury trials are still the best way to determine guilt and innocence. I just believe juries are only as good as the information put in front of them. So, and with that, I yield back.
Gentleman yields back.
Drew, I'm going to stay with you. Every day, members of Congress are subpoenaed on behalf of defendants in prison, people that have gripes against the government, and the president receives far more than one a day. Would you suggest that he should have to go to those places, show up and be deposed just because somebody wants to depose the president and says they have a basis?
Obviously, there's a general policy reason not to.
Okay, so the fact is that the Supreme Court's decision on limited immunity or immunity from prosecution, immunity from having to show up and be distracted from the work of the president is for a good purpose, and only in rare cases, such as Bill Clinton's case of a civil suit specifically about actions before he was president, has the court ever said it doesn't fit there, right?
I think that's exactly the problem you point out, is it's so rare that there was no need for them to.
Well, let's just get back to rare. There was need. They made a decision that still stands today, that Bill Clinton could be deposed as to his specific state actions prior to being president, but they ruled clearly that the president cannot be distracted from that. I'm going to switch to Mr. Smith. I'm going to let him drink his water. You said as a prosecutor, I'll go to you and to Mr. Judge Wilson, that this was not a fair trial, that it violated the rules that we count on for the admission of evidence. Is that correct? You both saw that in this case?
Yeah, if I may go first, I think the most glaring thing was some of the Stormy Daniels testimony, which, the implication from her testimony was that she was sexually assaulted by President Trump, which is, in any respects, so unfairly prejudicial relative to the crime.
So the judge clearly let evidence in.
And that was surprising to me, one, that the prosecutors didn't know that ahead of time, that this was going to come out, and it wasn't vetted ahead of time. So that's the most glaring example that I
So as a prosecutor, something that you dedicated your career to, there is a sense of balance. If you get in your unfair twisting, you normally expect the judge to, at least at a minimum, allow the defendant to present witnesses in response to that, or to offset. It was pretty unheard of that they only let you hit the guy and no one answer back.
Right, that part of it's concerning, and when you think about it, when we would prosecute cases, generally defendants had far more leeway, because it was like they're in jeopardy, they're going to jail or whatever. So even if they didn't have necessarily the most viable defense, it was rare to have a judge cut them off on it. And that's what just seems so striking. On one hand, it's the most extreme evidence allowed against President Trump, which is hard to justify, and then not allowing some sort of at least explanatory evidence.
As my time's running out, but yes or no, if I could, isn't that kind of imbalance very often exactly what a prosecutor doesn't want to see, because it leads to a high probability of a case being reversed based on not being fair? In other words, if you deny the defendant, you have a jeopardy of in fact getting a perfectly good conviction overturned because you didn't give them the proper opportunity for defense, didn't give them the charges in advance, didn't give them the evidence that you held. Is that right?
Yes, and it goes to question the motivation for this case. Was it just to get the initial conviction?
And now let's go to the motivation with Mr. Smith. You were denied the ability to answer a great many questions, so hopefully you'll be able to answer the ones you want to here today. Have you, in your history with the FEC, have you ever seen the FEC take state charges and link them to an FEC violation in order to get a felony and then take it to the federal court and charge somebody?
No.
So the federal government doesn't grab state cases to make something that is normally a fine and make it a crime, correct?
No, it does not.
Okay, and so if you had a situation in which, and this is an if because it didn't happen, but if you had a situation in which somebody took their own money and used it and then did not declare it, is that usually, there was failure to file, is that usually something that you would bring them up at the FEC and refer them for criminal felony charges?
It would be extremely rare that it would be referred for criminal charges. You'd have to show clear intent.
So in this case, specifically, the FEC made a decision that what they pulled in addition to state to make this a crime that they could charge a felony on is something that not only normally wouldn't happen, but in this case specifically was looked at and didn't happen. The FEC declined to prosecute because there wasn't a case here, right?
They not only declined to refer it to justice for criminal charges, but they declined to bring civil charges themselves, which is what you'd normally do if you just thought it was an error or something.
So it wasn't even worth a fine, much less a criminal prosecution.
Right.
Thank you. I yield back.
Gentleman yields.